You may have heard the terms beneficiary, executor, administrator, and trustee. A beneficiary is a person who receives a gift under a will. This might be money, shares, real estate, household goods, or jewellery. The executor is the person or organisation, such as New South Wales Trustee and Guardian, that you appoint in your will to administer your estate when you die. Some of the things they do include applying for probate, collecting your assets, paying your debts, and distributing your assets. If you don't make a will, or your will doesn't appoint an executor who is willing to take on the role, someone, usually one of your beneficiaries, may need to apply to be the administrator of your estate. They have a similar role as the executor, although because you didn't choose them to be your executor, there are some additional requirements they need to meet before the court will appoint them as administrator. The trustee is the person or organisation who is responsible for managing any trusts in your will. For example, if one of your beneficiaries is vulnerable or unable to manage their own finances, rather than gifting them your assets outright, you might set up a trust for them in your will. The trustee will manage the assets and the income for the benefit of the beneficiary for their lifetime. Estate planning is not just for the wealthy. It's important for everyone, regardless of the size of your estate. It's about ensuring you have a will so that your wishes are known. Estate planning also takes into consideration what assets will be dealt with by your will and what won't be. For example, superannuation. You also need to consider the best way to provide for your beneficiaries, taking into account financial matters like taxation and the beneficiary circumstances. It's also about what happens if you lose capacity to handle your own affairs by making an enduring power of attorney and appointment of enduring guardian.